seated. And the matter before the court is Penobscot 23-357, State of Maine versus Corydon Judkins. And I think we're being streamed live on the web, both with video and audio. And if counsel are ready, I would ask first that you introduce yourselves by saying your names for the record, starting with the appellant.
Good morning, Your Honor. Michelle King for Corydon Judkins.
Thank you.
Good morning, Joanne Lewis for the appellee, State of Maine.
Thank you. And Ms. King, if you're ready to proceed, we'd be happy to hear your argument.
Good morning, and may it please the court. There are two issues before the court today. The first is whether admission of a portion of Officer Reynolds' body cam video violated the Confrontation Clause, and if so, whether that violation was not harmless error. The second issue before the court is whether the trial judge abused his discretion in denying Mr. Judkins' trial attorney's motion to withdraw. Because the state has conceded that admission of a portion of Officer Reynolds' body cam video did violate the Confrontation Clause, I'd like to focus my argument on the harmless error analysis. When conducting a harmless error analysis, this court must be satisfied that the record as a whole demonstrates beyond a reasonable doubt that the error did not affect the substantial rights of the defendant or contribute to the verdict obtained. Now, a constitutional error results when, if there's a reasonable probability that it contributed to the verdict, regardless of whether there was sufficient evidence otherwise to prove the defendant's guilt. There are 5 factors that this court must consider when determining whether a harmless error occurred. Those factors were set forth by the United States Supreme Court in Van Arsdale and adopted by this court in State v. Warren. The first factor, importance of the witness's testimony to the prosecution's case. Secondly, whether the testimony that came in that violated the Confrontation Clause was
Counsel,
cumulative.
I do note that the green light is on. Can I move you to the other issue, actually?
Oh, certainly.
And that is, with regard to the motion to withdraw, how is there prejudice and how is that demonstrated?
Yes, Your Honor. It's
It
difficult.
wasn't like counsel didn't come or stood mutely during trial.
It's somewhat ambiguous, I will admit, in the record, but what appears to be the prejudice is that on the second day of trial, on the first day of trial, Mr. Judkins' counsel said that Mr. Judkins was adamant that he wanted R.A. called as a witness in this case, that they had had conversations, and he was very clear that he wanted her called as a witness. The next morning, however, counsel went into chambers and stated that the only witness that she was going to call was Mr. Judkins. And the inference is that at some point there was a disagreement or some kind of change of strategy as to...
The inference may be that they resolved their disagreement.
Fair enough, Your Honor. But when looking at the record, that's what I have, is that Mr. Judkins was adamant that he wanted her called as a witness, and he was not called as a witness, and that materially affected his ability to cross-examine her, for example, on how she obtained the injuries. And it was in the record that it was her intent, in fact, to come in and recant the version that she had given to the healthcare providers. And so without her being called as a witness, Mr. Judkins had no possibility whatsoever.
I guess, in a way, that also dovetails into the first issue because the witness did have to be unavailable in order for the prior statement to come in, but I guess that matter is somewhat resolved at this point. And the suggestion is that she was unavailable so that it may not have been realistic to get her there as a witness.
Correct, Your Honor.
So the parties agree here that admission of the body cam was in violation of the Confrontation Clause?
A portion of the body cam
Right.
Video, yes,
The key
from
portion,
10 minutes to approximately 10 minutes and 23 seconds, the state has
Portion
conceded.
where she is speaking about what happened.
Correct, Your Honor.
Which is about 30 seconds, correct?
A little bit under, I think, yes. Yep.
The state argues that there's sufficient other compelling evidence identifying your client as being the perpetrator of the injuries, statements to the medical personnel, the fact that he appears on in the apartment and the proximity of the parties. But your position is that's not the overwhelming, compelling type of evidence that would get them past the confrontation clause?
Yes, Your Honor, and again, the test isn't whether or not there was sufficient other evidence, it's whether or not the evidence was overwhelming. And in this case, there was no corroborating evidence other than, so we had RA's testimony that came in, well, through the video, but we also have her statements to the medical providers as to how it happened.
Right, and she said it was her boyfriend who committed these injuries.
Correct, Your Honor.
That's pretty powerful stuff right there. She said it as part of a statement to a medical provider, which, as you know, is rules of evidence. The assumption is people will tell the truth to medical providers. So that's pretty overwhelming right there, isn't it?
Well, I wouldn't call it overwhelming, no, Your Honor. I would certainly call it evidence. When you, excuse me, when you weigh that against the jury watching a video of a person speaking live and talking
Your
about.
position is that this is the only testimony from her lips. Otherwise, it's all it may be admissible under the hearsay rules, but it still is secondhand. And the video of her saying what happened is the only evidence before the jury is coming straight from her, and that in and of itself has to be powerful.
Correct, Your Honor. That's exactly what I'm saying. You can't discount the large impact of a jury watching not once, but twice a video that came in violation of the Confrontation Clause where
Except what we also have in that 10-minute video is a female voice pleading for them to come in, the officer coming in, seeing the victim on the couch, whimpering, battered. Clearly, there's been visually something between the two. And forget what she says. When asked, has anybody been injured? He says, we both have been injured. And then he gets on the stand and says, she fell over a chair. So you don't think that, combined with the medical expert's testimony about the actual injuries and what she said, two of them, that's pretty overwhelming?
I don't, Your Honor. And I would encourage you to watch that first part of the video if you haven't done so yet. RA is sitting there. They're both clearly excited and in a moment of something that just happened. There was most certainly an occurrence between the two of them. He's injured, she's injured. Mr. Judkins does admit they're both injured, but he doesn't make a statement at that time as to how it happened. But the impact of what she said, that it provides a motive. So the motive for why there was an assault, which is that he thought she was cheating on her. Her statement adds the component that there was a prior assault, which had been excluded at the trial. And it adds in the component that he said he would kill her if she answered the door. All things that, again, the jury heard not once, but twice. And I would suggest to you that there is no way to discount the impact of the jury hearing that. But not only that, the prosecutor focused on those components that came in violation of the Confrontation Clause in her closing argument.
But when we look at it, you're weighing what the jury saw, having seen the whole video, against the other evidence and saying that this colored their decision, which perhaps it did, but doesn't our analysis at this point to determine whether or not that other evidence is overwhelming? So if we were to just cut that out, was there still overwhelming evidence at the trial that would support the verdict of guilty? Am I wrong on that?
There are 5 factors to consider, Your Honor, and I wouldn't suggest that any one of the factors is more relevant than the other. And certainly, if you're looking at the weight, the amount of evidence that came in, I'm not suggesting that there's not sufficient evidence. What I am suggesting is when you look at all of the factors, including the importance of this witness's testimony, she was the only other witness to an event that Mr. Judkins testified to happened in a significantly different manner than she stated. So
Turning to the medical provider's testimony, are you conceding that that identifying Mr. Judkins as the perpetrator of the injuries was necessary for medical diagnosis?
I'm not conceding that, Your Honor, but the fact that Mr. Judkins testified and stated that there was some sort of incident between them, I don't think that there's any issue as to whether or not he was the other person involved.
So the issue boils down to whether there was any justification for whatever injuries he inflicted on R.A. Is that?
I think it boils down to whether or not there was evidence that they occurred in the manner that she suggested or they occurred in the manner that he suggested.
But there was no objection at the time of that evidence coming in, was there? Through the experts, through the medical experts on what she said.
Oh, no, Your Honor, no.
And you're not appealing that part of it?
Oh, no, Your Honor, that came in under a hearsay exception.
Can I go back a little bit, though? My colleague asked you about whether the evidence is overwhelming, but let me ask you a little bit more about the harmless error analysis. Does it matter? I mean, if we have said that when it's a violation of a constitutional right, including the confrontation clause, that the harmless error analysis is whether, after a review of the whole record, we are satisfied beyond a reasonable doubt that the error did not contribute to the verdict obtained. Is that the same as saying, oh, there's lots of other evidence? Is that, I'm not sure
Can you
that's the
state the
same.
last part? I'm sorry, Your Honor.
Is that really the same as saying, does that analysis equate to there's overwhelming other evidence?
I don't think it equates to that there's overwhelming evidence. And again, I don't think that the overwhelming evidence factor is the only factor that the court looks at. I think that there has to be, again, it's beyond reasonable doubt. So this panel has to be able to say beyond a reasonable doubt that the evidence that came in that should not have come in did not contribute to the verdict. And when you look at the evidence that improperly came in this case, I think it's my suggestion that the error was not harmless. And I would point you to a case that I found out of Massachusetts, which was Commonwealth v. Wilson, a case that was almost directly on point to this case. In that case, there was a 911 call, and a portion of the 911 call came in under the excited utterance exception. And in that case, in the portion that properly came in, the victim testified that she and her husband had an argument, that he choked her out, and he said that he would be back in 15 minutes to kill her. The police arrive on the scene. 10 minutes later, the police officer takes a statement from her, and the facts that she added in were a lot different than the ones that came in through the 911 call.
And is that the key here? In other words, that while it may have been cumulative to the general point of whether she had been assaulted by him, that there were specifics in the video, such as he would kill me if I answered the door, he took my phone, wouldn't let me call the cops, beat me really bad the night before, that were not cumulative, that were unique to the statement that came in through the video.
That's my exact point, Your Honor. And within the video, in those 30 seconds, she's pointing to the injuries that she had obtained previously. So,
Counsel, I understand the Chief's point about the difference between the two standards potentially, but how are we to assess that? In other words, if we aren't able to look at the overwhelming amount of the other evidence, how do we assess whether this particular evidence contributed to the juror's verdict?
well, I would suggest to you, Your Honor, that it's a weighing of factors, because there are 5 factors, and so far as I've read, not one factor should be given more weight than the other. You have to look at the evidence, you have to look at how important this witness was in the case. But I would further suggests the fact that the jury asked to see this video again is the best piece of evidence that you have on how much they relied on this evidence.
But there was also 10 minutes of other admissible material in that video. So we can't say it was the 23 seconds, which was consistent testimony with what she said to the medical experts that was admitted.
Well, the 10 minutes prior to her statements that came in, again, I don't know if you've seen the video, if when you do watch the video, it's her,
I think most of us have.
perfect.
Probably all of us.
Is her sitting there and saying nothing and looking upset. He's also upset. And so I think the inference is that the jury wanted to hear what she had to say about how this happened, not how she looked when she was sitting there for 10 minutes. And that's the impact, again, of this video coming in, because she introduces concepts that didn't come in any other way.
But it almost leads to a conclusion of structural error. In other words, any time a video or evidence is put in, if the standard did not contribute beyond a reasonable doubt, I'm struggling with how we make that assessment.
And although he may not have been in the intersection when the question was asked, you are free to answer it.
Yes, sir. I think, again, it's, you have to, and I understand the struggle, I think you have to look at the importance of this witness in the case, and I think you have to look at the evidence that, the different evidence that came in that had no other support in the record. And when you do that analysis, look at each of the factors. And I would suggest to you that when you do that, the fact that the jury, again, asked to look at the video twice, and what came in improperly was highlighted to such an extent by the prosecutor in her closing argument.
Thank you, counsel.
Thank you, Your Honor.
And Ms. Lewis.
Thank you. May it please the court, counselor. Just for the record, I am the counselor, the prosecutor who tried this matter. So just let the court know. Addressing issue number 1. Appellant argues when Officer Reynolds asked Ms. Allen what happened, an active interrogation began and should have been excluded. Specifically, appellant is referring to 10:02 to 10:23 of Officer Reynolds' body cam, 21 seconds. The state concedes that Ms. Allen's 21-second response was testimonial and should have been excluded. The rest of the video that was admitted is not challenged on appeal, nor was any other of the testimony or physical evidence presented at trial. After a review of the whole record, the state believes the error was harmless since the error did not contribute to the verdict obtained. And that would be my response to Justice Douglas's question and what the state believes the court needs to look at. Did the error contribute to the verdict obtained? There was some discussion that the 21 seconds is non-cumulative. I'd like to take this protected time to just add a few points how the state feels it was cumulative. The first phrase, approximately 5 seconds, he thinks I've been having these affairs and everything, and it's just BS. The state would first say that it was not material to conviction, whether or not they were having affairs. But it was clear from the defendant's testimony, as well as from other evidence presented, that the appellant and Ms. Allen's relationship was fraught and unstable. He even testified to that. As far as the next phrase, approximately 5 seconds, and last night he beat me real bad, this is the second part of it. I'd like to remind the court that this is a superseding indictment that took place over 2 days, March 3rd to March 4th of 2023. So the jury was aware that this was, at least in the indictment, a 2-day allegation. The defendant also testified to multiple days of drug use and conflict between two of them. The last part, he took my phone, I wanted to call the cops, he wouldn't let me, he was going to kill me. The state would offer that when Officer Reynolds went to the door, He knocked, the door was locked. He heard, come in, from Ms. Allen. Her voice sounded concerned. Finally, the door was opened, and it was the appellant at the door. The body cam shows that he was at the door, the officer was on the other side of the door, and Ms. Allen was in the background. She was moaning, she was groaning. We saw her with frozen chicken holding to her face, to her chest. The officer was, the appellant was between the officer and the victim, and the state would suggest that that is evidence that he was trying to prevent her from.
Well, let me go more specifically,
Yes.
though. Her statement in the video is, he would kill me if I answered the door. Any other evidence specific to that, other than inferring that the door was locked?
So I'm suggesting that the other evidence is that when the door was opened, after she says,
Is
come
there
in,
other evidence of a threat to kill her?
there is evidence of strangulation. So the
Of what he
state,
may have done because of what she reported, but not of a threat specifically to kill her?
there is no verbal threat on the record that he said, I will kill you.
Other than her statement in the video.
Correct.
Any other evidence that he took my phone and wouldn't let me call the cops?
No.
And I know you referenced the indictment says that the events took place over 2 days. Is there any other evidence that he had beaten her the night before the police were there?
From her statement to various medical personnel, she reported it happened a few hours ago to 24 hours ago.
So-
Justice Douglas referenced the difficulty in the standard to be applied when we're looking at confrontation clause cases. And we've issued some language in various cases, but one kind of stands out in my mind. In the Forsyth case, we looked at that and concluded that given the standard of review, whether it is reasonably possible that the error contributed to the jury's verdict, regardless of the sufficiency of the other evidence to support the conviction, the error is not harmless and the judgment must be vacated. Some pretty affirmative language in that particular case. Your take on what standard we should use in determining whether or not the error was not harmless and the judgment must be vacated?
Your Honor, I do believe that the standard would be that the error did not contribute to the verdict. And I do think that we need to look at.
How do you know it didn't contribute to the verdict? You said that, but
Right.
I don't understand what you're basing that on.
Oh, Your Honor, I'd like to explain all of that then. Thank you. So Officer Reynolds, and I'm going to go over the facts, and please, obviously, you'll interrupt me if this is information you feel you already have. Officer Reynolds gets to the door. There's a delay in opening the door. He hears that she's stressed. He sees her holding, left side of her face is bruised and swelling. She sounded concerned.
But what I am going to stop you. Because,
Okay.
But I think that what you're getting to is there's lots of other evidence.
Correct.
Okay. Is there any other basis that we know it did not contribute to the verdict other than the fact that there's lots of other evidence?
That's an interesting question. I would say no, unless we were in the jurors' minds per se.
But didn't we adopt in Huntley, I think that was following the U.S. Supreme Court in Delaware and Van Arsdale, essentially a multi-factor, in other words, to talk about the importance of that particular person's testimony in the case, whether it was cumulative, the presence or absence of evidence corroborating it or contradicting it on material points, the extent of cross-examination otherwise permitted, and of course, the overall strength of the case. So the strength of the case is one factor, but it's not the only factor.
Correct.
How did the other factors weigh in favor of suggesting, as you do, that it did not contribute?
Well, we're looking at 21 seconds versus, and really very short period of time, versus photographs, video, non-testimonial video that came in showing Ms. Allen's appearance, how she was distraught. The defendant's own testimony was, as Justice Maloney called it, obviously false. And I believe that Deputy District Attorney Mark Rucci argued, I believe rightfully so, in the brief, that just the defendant's testimony on his own left the jury with two choices. One is Ms. Allen did this to herself, that she beat herself, and the bruising was terrible. I don't know that anybody would disagree with that, versus there was this domestic violence event that the state proved. So the state feels like that's one obvious reason. The medical personnel corroborated each other, so there really wasn't any conflict in their individual testimonies. They also
There was some
talked.
testimony by one of the experts that some of the physical condition, or strike that, some of the medical conditions that the victim had might have manifested themselves physically and been visible in the viewing of the video, correct?
Are you referring to perhaps that she had COPD or something like that?
Amongst other things, yes.
And that was argued by Ms. Corbett for the defense in her closing. She argued that her airways were blocked or she was coughing because she has COPD.
And also was suffering from fibromyalgia, which might have caused her to be in pain at the time that she was being
Correct.
Videotaped.
Correct. And that was argued, I felt, artfully by Ms. Corbett and heard by the jury for them to consider.
So the factors that you itemized in response to the chief's question, you say, looking at those, that it's your conclusion that it is not reasonably possible that the Confrontation Clause error contributed to the jury's verdict.
That is my conclusion, Your Honor,
Well,
correct?
because you're saying there was really a binary choice for the jurors. They either had to believe his story that she fell over a chair, or they had to conclude that it was a matter of domestic violence. And I think what you're saying is you exclude that 23 seconds, and it's pretty clear that his story was not one that they were going to accept.
Once he testified, I believe that's the position the jury was put in. So that plus the other evidence, which I do feel that there is cumulative evidence to the 21 seconds. I acknowledge there's no conversation about taking a phone or a threat, I'll kill you. But if you look at other evidence, physical and testimonial, that there is cumulative evidence to the 21
But the test
seconds.
isn't whether the other evidence is sufficient. The question is whether the unconstitutionally admitted testimony of the testimonial statements of the alleged victim in a domestic violence assault contributed in any way to the verdict. And we have to say there's no reasonable possibility that this video of the alleged victim influenced the verdict. And the state has the burden on that, right?
Absolutely, or led to the verdict. I mean, I don't know about influence the verdict versus these 21 seconds led to the verdict. And it's
Well,
the state's
contributed
position.
is the word we've used, contributed to the
Contributed.
verdict.
And the state does take the position based on all the evidence, and there was a lot of evidence that it did not contribute to the verdict.
There don't appear to be
Okay.
additional questions.
Well, thank you very much.
And as I understand it, you did not reserve any time for rebuttal, so. Okay. As is our usual practice, then, we will take this matter under advisement, issue a written decision